We agree to
Going on to
disagree.
the question of redress, you don't actually have a policy with regard to how to handle claims that are brought against the organisational claims made, not necessarily in a court, but someone says, look, I was abused in the organisation one way or another. I want compensation for this. I want it to be dealt with. You don't have a policy that deals with that, do you?
We're certainly in the process of developing that, particularly since the release of the paper on redress from the Royal Commission. We've studied that and we're basically in agreement with many of the proposals in there. We don't take the view that we're waiting just until we hear the final thing, but there still are a number of questions that it seems to have to be resolved.
And that's this 2015 Royal Commission report on redress and civil litigation that you're referring to, is that right?
Yes, that's right.
Okay, so that's been around for a couple of years now, but in short, you're saying you're working on a policy which we can expect at some stage?
Well, it's only in recent months we have had one request some time ago, probably more than a year ago, that we corresponded back with, and the claimant changed the solicitors they were using. So it's only just in the last, this week, the last few days, that we've received a report back from the legal firm that we've been using to deal with the requests that have come in.
Well, never mind individual cases. Can I just understand this from you? Is it the case that you're working on a redress policy and one can expect to see one in due course?
Yes, definitely.
Thank you. And has the organisation engaged with or reached a position on the Commonwealth Government's proposed national redress scheme that was announced in November last year?
No, not at this stage. Could I raise a question on this, which is of concern to us in being able to address this issue of redress, Mr. Stewart? Would that be acceptable?
Let's hear what it is, Mr. O'Brien, and then I can tell you whether we can answer it or not.
Okay, so with regard to the finding of the Royal Commission, with our bringing in all of the case files that we had, because of their being investigated, the finding was that makes all of them institutional abuse, even though the greater majority of them were not actually according to the terms outlined in the redress scheme as being institutional. So there's two implications for that I would see. One of them for us as an organisation, if the number of case files is the basis for determining maybe our share in a redress scheme, we would feel that would be not in the interest of being fair and adequate, because
You needn't worry about it. Your organisation came clearly within our terms of reference because we are required to look at the response of your organisation.
Yeah, which we don't contest.
And that response, of course, when inadequate, will cause damage to people. You understand that?
We understand, yes, that's a response.
And from the evidence that we've had, that is likely to have happened. You may not be an organisational abuser as such, but the response of your organisation may have compounded, indeed very much compounded, the damage to that individual. As far as the redress scheme is concerned, if it takes the form, or roughly the form the Commission has recommended, your liability will be determined on a case-by-case basis,
right, and
you will be contributing on a case-by-case basis.
Yes, so that's...
The files that we sent off to the police, well, may or may not represent a part of your liability. I don't know.
Okay, so according to then the terms set out, I think it's on page 38 on the redress and civil liability, the recommendations, it outlined just what constituted institutional abuse. If that's as we understand it, then that would be something that would resolve some of the issues we have in our mind.
Well, you must understand, Mr. O'Brien, that this was the recommendation of the Royal Commission. This has now been taken up by the Commonwealth Government, and the government's in the process of consulting the states and territories and organisations, and how it will end up may be close or not so close to what was recommended, one doesn't know. So my simple question is to what extent is your organisation engaging in that process or taking a position on whether it should engage in that process?
So at the moment, we haven't had any actual statement of claims, but we have had correspondence from 6 individuals. So we're formulating on the basis at the moment, still trying to determine what sort of extent of claims we would have, because I do understand from the report that each organisation would still be responsible for their own claims, which is part of the recommendation. If that was what the National Redress Scheme brought in, that possibly will affect which institutions and states would opt in for that. So I think it's still a little bit too unclear for us to commit ourselves definitively. We're still working through the process of determining just how we will handle redress.
You haven't ruled it out?
We haven't ruled it out, and we certainly, if there are any victims who are victims through institutional abuse from Jehovah's Witnesses, we would do everything in our power to assist them financially and spiritually.
And then finally, dealing with the question of the involvement of women in decision-making in the organisation. You're aware of the findings in relation to that. I won't repeat them. Your response is given tab 1, paragraph 7.5 and 7.6. So 7.5 is a broad statement. 7.6, you say women can and do participate in the process of presenting allegations of child sexual abuse to the elders. So I take it you mean that as a matter of ongoing practice that happens. Is that what you're saying, Mr. O'Brien?
This is to do again with the entire process of receiving an accusation to the completing of giving support to a victim. So the role of women in the process, the only restriction that Jehovah's Witnesses have on that is in the actual judicial committee, which is dealing with the perpetrator, not dealing with the victim.
Yes.
So women can be involved in the entire process. The victim never has to confront the perpetrator, doesn't have to sit in on the judicial committee.
That's the point, isn't it? Your answer in relation to decision-making is that you are scripturally bound, that the decisions can only be made by men.
Yes, once again, that's a scriptural requirement that we adhere to.
And at the end of that paragraph, 7.6, you say, see paragraph 13 of the August 1 letter. I take it that's in support of the statement that complainant may be accompanied by a confidant, etc. That reference seems to be wrong because paragraph 13 at tab 7 doesn't say anything about that.
I might just get Mr. Spinks to comment on that. Is the expertise in the letter?
So again, for the very reason you raised, Mr. Stewart, we've acknowledged that, and so in the current Australian safeguarding policy, and we've made the very recommendation that you've just raised. We've, if I can, the March 2017 child safeguarding policy.
Tab 11.
Paragraph number 10.
Yeah.
Says, again, the victim's never required to confront his or her alleged abuser. The allegation can be made in the form of a written statement. And then two sentences on. Adults who were victims of child abuse may be accompanied by a confidant of either gender to provide them with moral support when meeting with the elders. So, again, it's a valid point.
I just want to come back to something I dealt with early on in case I didn't understand it clearly. This document you're looking at now, it's been approved by the branch committee but not yet finalised in case you want to make amendments following this hearing. Is that right?
We were ready to distribute it and made the observation that if something is said at the public hearing that needs to be clarified, then that's what we want to do. But our understanding at this stage is it's completed and subject to any other observations that we can include in it, but that's correct.
Right, so you anticipate then finalising it shortly, would that be right, in the next week or two?
That's correct.
Yes. And then to whom is it going to be published exactly?
To congregation members.
To all congregation members.
So that's the audience for this document, is all congregation members.
And how will that be done?
Well, that's the decision the branch committee has got to make, whether we're going to do that in a printed form or whether it's going to be distributed through electronically through the electronic mailing system for each congregation and made available locally. That's either way, it's available to all congregation members.
But you give the undertaking now that rephrase it, the undertaking now that the intention is that it be distributed to all congregation members.
Yes,
that's the audience for this document. And sorry, Mr.
Yeah, I can speak on behalf of the branch committee that we're authorised to make that available, that it will be available to every member of every congregation in Australia.
Well, making it available may be something different to what I'm speaking about, because making it available could be if someone asks for it, they can have it. I'm just seeking to determine whether it's actually going to be actively distributed so that people have access to it without having to ask for it.
So if I could, I'm not a part of the branch committee, but the recommendation that we've made, and I believe will be acceptable, that every congregation member will have it made available to them, whether that's through a paper distribution or an announcement or made available at the Kingdom Hall. That's the only decision that's got to be made. But every congregation member will be made aware of it and a copy made available to them in each of the 800 congregations around the country.
Because you'll understand and accept that to the extent that people's rights within the organisation are articulated in this document, they need to know what those are. And
Absolutely.
yes, I have nothing further on.
Mr. Tockley, do you have any questions?
No, Your Honour, there's no regulation.
Before we close, I have one question. I want to refer you back to paragraph 1716 of tab 1. It's paragraph 716 of tab 1.
716.
What's on the screen is not that.
Joint statement.
Page Ringtail 32.
I would summarise that as, in its totality, as indicating what we would describe as a pastoral response. Do you think that's an accurate description?
I don't understand the question. I apologise.
Well,
A religious response.
yes, pastoral means looking after the flock.
Yes.
I mean, this is about empathy and compassion and so on. And that's all very well as it goes, but you would now understand from the Royal Commission's work that the often very grievous effects of child sexual abuse are life-changing and life-affecting, and therefore people need, and I stress independent, expert independent therapeutic intervention, sometimes called counselling, but it can be better described as I put it. I want to know, in terms of your response to the 1,006 files of victims and subsequent victims that have come to your attention, whether the Jehovah's Witnesses branch in Australia have assisted or decided to assist or planned to assist victims or survivors with respect to therapeutic intervention by independent experts.
Yes, so on that, Commissioner, we, of course, allow the individual to decide who they would like to use, but certainly we will assist in funding any of the victims who fall into that category automatically under the terms of reference of the redress scheme. We would see part of the redress would be covering medical and ongoing psychological or psychiatric help or some other form of...
And you do that presently?
No, because we haven't had any actual claims or correspondence until this last mainly 6 to 8 months. And it's only just at the point now that the legal firm we're using, Gilchrist Connell, have now written to the solicitors of the victims and have now presented us with some suggestions for consultation.
Well, this is not really about the law. It's about going further than compassion and actually providing people help for grievous psychological harm. Surely you're not going to wait until 2018 when a redress scheme finally comes up to reach out to victims and survivors?
No, not at all, Commissioner, because we have already now been in contact with these. So the ones who've made claims, we're not actively going out looking for other victims because we don't know what the situation is with them. But those who've corresponded to us, who've sought some form of redress or compensation, we're at the point now where we can address that long before 2018.
Well, perhaps I could ask through you, Mr. Stewart. Mr. Stewart? Perhaps I could ask through you if you could give us some formal advice as to whether you are assisting anyone at present with financial help for independent therapeutic advice as a branch.
We'll follow that up, Commissioner.
Nothing further, nothing arising from that, Mr. Tockley?
No, there's nothing to be done.
Very well, thank you. That brings this particular hearing to an end. And thank you both for your contribution, and you are now excused, and we'll adjourn until 2 o'clock.
Stand.